Hi there. We continue exploring privacy issues and talk about every aspect of privacy law which your business must be aware of. And today we talk about Virginian privacy laws and about companies, businesses which need to be aware of this legislation because, for example, they need to be compliant with it. So today we defined whether or not your company needs to do this in your business operation. So let's move and see what we have next. In 2021, Virginia became the second state after California in the United States which enacted comprehensive consumer privacy legislation, with several key differences between the two laws. The Virginian Act offers an alternative model for other states planning to enact their own privacy legislations. The Virginia Act grants several essential consumer privacy rights to residents of Virginia, including the right to access their personal data, the right to opt out of selling, and the opt out actually of selling from their data, which companies collect in order to target advertising for them. This law also outlines regulations related to sensitive data. It also reflects such issues as de-identified data and performing data protection assessment. All these issues are covered by Virginian Act. What does the Virginian privacy law actually towards Virginian residents? It provides us with a range of different privacy rights. Some of them you can see right now on this slide. It is like the right to know if a consumer is if a controller processes or collects a consumer's personal data. The consumers can also access this data from a controller, so they can send a request to get this. They can also ask, for example, to delete their personal data, or when information is inaccurate or outdated, they can also request the correction of these inaccuracies. They can also ask to obtain a portable copy of all information which a controller collected from consumers earlier, so they can do this to request it in order to, for example, to transfer this data to any other party. The Virginian Consumer Act empowers Virginia residents with more control over their personal data. The Virginian law empowers them to make informed decisions about their data. They can choose which information businesses hold, how it is used, how they can request a deletion or correction, and all this is guaranteed by the new enacted Virginian Act. Who is affected by Virginian Consumer Data Act? Actually, it applies to all businesses who perform their business operations for money. So in law, this is defined like for-profit businesses. In this case, we do not mean whether a company established in Virginia or not, because the main requirement that you need to take aware of is whether or not your company meets threshold criteria defined by this act. And in this presentation, in our further slides, we'll talk about this threshold criteria that defined by the law. Okay, so let's see on the first one. I would call this criteria territorial. It's actually a Virginian Act affects all for-profit companies that do business in Virginia or that produce products or offer services targeted towards residents of Virginia. So in this case, the Virginia Act is exterritorial. It means that a company's physical location doesn't matter. If your company meets the criteria and target Virginian residents, they will for sure need to comply with this act. So do not be attracted with this with the concept that if your company just, for example, target Virginian residents, you will need to do this. Or if your company, for example, is not established in Virginia, sometimes this concept is misunderstood. So to do this, to accurately define whether or not your company needs to comply with it, we will define this criteria in the next slides. Okay, what is about targeting residents? Because we mentioned that if your company targets towards Virginia residents, or if your company sells or provides services towards Virginia residents, it will need to comply with it. So simply offering products or services towards Virginians even through online channels, it can trigger Virginian Act. So you will need to comply with this act in this case. Compliance needs to consider companies actually need to consider if their marketing efforts reach Virginian residents. Sometimes when your advertising professionals, your advertising team launch some advertising campaign, they make some settings and they define which residents, which audience they want to target. So you will need to check for sure whether or not your company actually does this. If you do this, if you check this, you will be for sure understand that, for example, your target towards Virginian residents, and then you can move next and check other criteria, which we'll do in the next slide. So the second criteria is numerical. This act applies to businesses that control or process personal data of at least 100,000 consumers during a calendar year. This means any for-profit company, even if headquartered outside Virginia, it must comply with this act because we have a clearly defined criteria which is defined in 100,000, and even if your company makes established in other United States state, or even if a company, for example, does business outside the United States, I mean it's officially registered, not in the United States, any of these cases, you will need to check this numerical criteria first. Okay, what is about definition of a consumer, which we'll talk about earlier. A consumer under the Virginian privacy law, it is defined as a natural person who is a resident of the Commonwealth of Virginia and acting only in individual or household context. This definition specifically excludes a natural person active in any commercial or employment context. Information collected when you act as a representative or business, such as making a purchase for a company, it's not covered by this law. It's only this law covers exclusively persons, data subjects acting as individuals, right? In doing their non-commercial activities, let's say in such way. The Virginia Act prioritizes protecting individuals' needs, individuals' consumer data, and not the business data. This definition helps Virginia Act target the protection of personal data used in their everyday consumer activities. So do not forget about these important differences. And third criteria, which you will need to check before making sure whether or not your company needs to follow this law. The Virginian Act defines the sales of personal data as the exchange of personal data for monetary considerations. So this law will apply to businesses that control the process of personal data of at least 25,000 consumers, I mean Virginia residents. And it also needs to derive more than 50% of their gross revenue from the sale of personal data. This targets companies that profit significantly by selling consumers information. This criteria focuses on businesses that make money from selling their personal data of their users, and in this case we talk about Virginian residents. Even if companies handle less data, actually over 25,000 consumers, that data sale is their main source of income, like 50% and plus, they must comply with this law. And let's also compare definitions of controlling and processing. One of the key definitions of Virginian law is that processing, it actually refers to any aspect of operations or a set of operations performed by a company from manual or automated means, such as like collecting, storing, disclosing this information, analyzing, and any other scope of personal actions with the data. So it will be the definition of processing. If we talk about controlling, we talk about a company which determines the purposes and means of processing of personal data. So let's say your company develops a website and it defines actually the scope of personal data which it needs from users to fill in the form when they do their registration process. But one of the functionality of the company which it has, for example, it will be like cart within the website when your user needs to fill in financial information about themselves in order to perform a purchase or like order some products from your website. And this specific function you do not do by yourself, but you want to engage third-party processor to perform it on your behalf. In this case, you will stay a controller because you defined actually the scope of data which you need for your company to collect from your users, but you delegate this function of processing this data to another party. In this case, we talk about third-party processor. In this case, you will save the function of a controller, but this specific function, like related to processing their financial information, it will be delegated to another party. And in this case, you can see like a distinct difference between a controller and processor. Okay, what's next? Let's see on the exemption from the application of this law. You can see on the slide right now. You see there some exceptions, some entities and organizations which do not need to comply with this Virginia privacy law. And in most cases, when we talk about any United States privacy laws, we always speak about like governmental organizations, bodies, authorities, commissions that perform their work not in a for-profit capacity. We speak about like performing some regulatory, some governmental work. And if we speak about such companies, they will always be exempt from such kind of laws. If we speak about financial institutions or organizations that are subject for other federal regulations within the United States, they will also be exempt from this specific Virginia Act. If we speak about covered entities or business associates governed by other federal regulations such as Health Insurance Portability and Accountability Act, they can also be exempt from this law. All companies that do their business, they do perform any operations for non-profit, right? They do not make money for this operations, they will be also exempt from this. And also universities and colleges or any institutions of higher learning, they also exempt from this act because they also are subject to other federal regulations. And then the last but not the least important rule, which you will need to be aware of, is that your business only needs to meet one from the mentioned criteria in order to comply with the Virginian Consumer Privacy Protection Act. So you don't need to be, you don't need to mark all. You'll need to check all these aspects. I mean, all threshold criteria which we talked about today. But in order to comply with this act, you do not need to be a subject of every of this. For example, a company could be exempt from this law if they handle less than 100,000 consumers' data, even if they target Virginians, yeah? Or they could be exempt if they, for example, target Virginians, but they don't make a significant amount of money from selling this data. So, for example, less than 50% of revenues. So be sure to check accurately every of this threshold criteria we talked about today to make accurate estimations, assessment of whether or not you are a subject of this law. Okay, guys, today we finished talking about this topic. I hope that this information would be really useful, yeah, even if you do not target residents from Virginia or if you're established in Virginia, because you will need to understand that despite the fact that we have numerous privacy laws worldwide, and specifically every United States, every state in the United States have their own privacy regulation. You'll need to be assured of every piece of this. That's why we talk about Virginia today, and in our next video we'll talk about next states as well. So keep in touch and see you in the next video. Bye, guys.